On that note, I am part 3 of this series that Teresa's talking about, and there will be a video forthcoming. So, my name is Chris York. I'm one of the appropriations and records engineers, and happy to be talking to you guys today. And I'm the only thing standing between you guys and lunch, so we kind of have a love-hate relationship going on here. But I'm hoping to maybe inject some warm fuzzies in you and just want to let you know it's not very often you get me in one of these neck chokers. So just to let you know, I got married this last year and I didn't even wear a tie to my own wedding. So hopefully that helps you feel better about what's happening, and that'll fight off the hunger pains that you guys are feeling and replace with warm and fuzzies. So if not, lunch is just down the road. So it's coming here shortly. So just to give you a bit of a roadmap as to where we're headed, I'm going to talk about extension of time requests, proof of beneficial use, proof affidavits, certificates, and we'll finish off with a little bit of a title discussion. So this flow chart you've seen, and now you have an idea of where we're headed. We're going to talk about that third part, and so that's what I'm going to cover with you today, and then in addition talk about title. All right, so you got an approved application, and in your order of the state engineer there was a proof due date in there. As Teresa mentioned, it's typically 5 years. Sometimes for larger projects you'll see a greater period of time, but typically 5 years is what you'll see. And we at the Division of Water Rights keep track of that date, and we'll let you know when your proof due is coming up. Specifically, we will let you know 60 days in advance of that proof due notice, or the proof due date. That's kind of your, hopefully a Kickstarter, lights a fire. If you haven't done anything at this point as far as submitting something to us, this is kind of just your friendly notice to say, hey, it's time to submit proof of beneficial use, or if your project isn't quite done yet, to submit an extension of time, which we'll talk about in just a moment. If nothing is submitted timely, your application will lapse. So if in that 60-day, if you haven't submitted anything, you get the proof due notice, and you don't do anything in that 60 days, your application will lapse, and we will send a final notice of lapsing. And at that point, you then have 60 days from the notice of lapsing in order to reinstate your application. Sometimes people don't realize, they maybe they didn't pay attention to these letters we're sending, or didn't take it seriously, and people are like, well, I'm using my water, it's okay, it won't lapse. Even if that water is being put to beneficial use, if you don't file your proof of beneficial use or an extension of time, that still can lapse. All right, an extension of time request. There is a form on our website, and Jim Reese will show you where these forms are, and there are fees associated with that. So you submit the form filled out with a fee to our office, and that's the mechanism you will use in order to submit an extension of time. This is done when you have started putting your project to beneficial use, but isn't quite completed. So and it requires on your end some diligence has to have been trying to put this to beneficial use. So let's say maybe you drilled your well and your house is partially complete, but it's not quite done yet. So you're just going to fill this extension of time out, let us know where you're at and what's going on with your application, and that's what you're going to tell us. And due diligence doesn't mean you were sitting on a yacht for 5 years and thought, maybe in the next 5 years I'll come back to Utah and put that project in. So there does need some diligence shown on there. So let us know what that is. If you're submitting an extension of time after you've extended out for 14 years, there is an advertising requirement. So the traditional fee for an extension of time is $50. If it's after 14 years, it will be $150. And that's because it's going to require more of a review on our end, and there's this advertising component. So this extension of time will be reviewed by the state engineer, and a recommendation will be made. So if your project is complete and you can submit proof of beneficial use to us, this doesn't mean you have to wait till you receive that 60-day proof due notice. If the project is complete, by all means, submit a proof of beneficial use now. You don't have to wait for somebody from the division to contact you. So in fact, it's much better for you and us if you just submit it when you're ready and done with that project. Proof of beneficial use is submitted on applications to appropriate, change applications, and exchanges. Typically, and I'll talk about when there is one caveat when a professional is not needed to submit proof of beneficial use, and I'll talk about that in just a moment, and it's not. But typically a professional will be required, and this is because we ask for certain details that we feel require a professional, and this could be a licensed land surveyor or professional engineer. We ask for the point of diversion and place of use descriptions to be given to us, and we ask that they survey those locations and give us an idea of where this is happening. And we also ask that they give us a measurement from the source and kind of give us an idea and confidence that the source is able to handle the uses that were proposed. And just in addition, when you have a licensed professional, verifying, giving their stamp of approval, it just gives us a kind of lends credence to this. So that's what we're asking for, and why we ask for a professional to be submitting that. And our proof of beneficial use forms are available, again, in the same location that Jim Reese will show you on our website. And these are reviewed for completeness, and what we're hoping for is to be able to process that and issue a certificate of beneficial use. All right, I told you there was one kind of caveat when a professional is not required, and that's when you would submit what we call an affidavit of beneficial use, or we commonly call it a proof affidavit. Kind of use the same, and that's when it falls into this category of our small domestic uses, and Teresa kind of mentioned that's when it's a domestic use and a 1/4 acre of irrigation or less, and 10 equivalent livestock units or less. That's when it kind of fits into these small domestic uses. There's a couple requirements when we talk about proof affidavits. One of them being we ask that you submit a certificate of occupancy with that. We want to know that this home in fact was built and that you're now occupying the domestic component of that application, and sometimes people have trouble obtaining a certificate of occupancy, and in which case we've allowed people to submit a tax notice showing that there is a home on there. So, in addition, the affidavit of beneficial use, again, another form on our website, will need to be submitted with this. And we require a plat map. This kind of helps us. This is kind of that surveyed location component that we can identify the parcel and where the uses are actually occurring. And in addition to that, we require a map of beneficial use, and basically this is the applicant showing us where exactly the livestock and or irrigation and the home uses are occurring. So this is the proof affidavit form. It's pretty straightforward and kind of telling us what uses are happening and where they're happening, and again that form is with our all the forms on our website. This is a typical map of beneficial use, and I'm gonna tip our hands a little bit, we've been working on an online wizard that will help us through this process, and I was really hoping to be able to talk about that more today. We ran into a few challenges and weren't quite able to release it to the public yet, so I didn't want to talk about it too much because it's not quite available yet, but it's going to be available here shortly, and it's going to help the applicant fill out the forms, and also will help the applicant produce a map. So it's not going to be just a straight hand-drawn map. However, it's not quite ready yet, and when we do roll it out, a video will be created to help show what to do and how to produce this. So stay tuned for that. We'll let you know. But this is what a typical map could look like. We're looking for the uses to be distinguished, and this comes in, locate where your home is, where the domestic residence that this affidavit is associated with. Show us in hatching where any irrigation is occurring and where any livestock watering may be occurring. So if you have troughs, or if they're watering directly from a spring or a well or whatever it may be, show us where that is. And then we also ask that the well be identified and that you locate from 2 property corners distances to that well, so we can easily identify it if we need to do some field investigations or find it in the future. And then just some basic elements that will be associated with it, like a north arrow, the water right number, the parcel ID number, which is critical, and that will help us identify exactly what home this is associated with, and will help in future, maybe water transfer or transfers that may happen from owner to owner. All right, and then just some general things that we get asked about a lot. Again, I mentioned that the goal is to get a certificate of beneficial use issued, whether you submit a traditional proof of beneficial use or a proof affidavit, they both, if they're acceptably filed and completed, will receive a certificate of beneficial use. If an applicant is uncomfortable submitting a proof affidavit by themselves, they may hire a professional. That's perfectly fine. This is hopefully going to save you some money. But if you do feel uncomfortable and don't feel like you want to do that, you are welcome to have help of a professional. As I mentioned, we will allow a tax notice in lieu of a certificate of occupancy if that cannot be obtained. And they are submitted on exchanges, change applications, and applications to appropriate. It's important to note if this is based on shares of stock in an irrigation company, we do need the irrigation company to sign the proof affidavit or proof of beneficial use. So just keep that in mind, and especially if you're butting up against a proof due date, just keep in mind time for that. All right. So the certificate on this slide is in black and white, but you'll notice one thing you'll notice if and when you do receive a certificate, it's got a gold bar on the bottom. That's what distinguishes a final certificate being issued. The certificate is reviewed by the state engineer and is signed by the state engineer. It's reviewed for correctness, and this means we'll look at your order of the approval, how it was approved, the proof of beneficial use, make sure it's consistent, and then we'll ultimately issue the certificate of beneficial use if everything looks good and correct. We encourage people to record this with the county recorder's office. It's not mandatory, but we do encourage that. And it is subject to the reconsideration and appeals process that Teresa discussed with you. So once you receive your certificate of beneficial use, basically, it's just use it how you were approved and continue to put it to beneficial use. And if that nature of use or how you're using it changes, then file a change application and we'll get you going through the process again to get that approved and make those changes however you want to use it. So with that, okay, we got a question and James is on his way with the mic.
Yeah, before you move on,
Yeah.
I've got a question. Exchange application that was approved prior to 1990 timeframe.
Yeah.
That did not require in that approval a proof of beneficial use. I was told we're just fine the way we are. It was in the 70s that
Yes.
was approved. So what's kind of the background behind that? I've never understood the background of that.
Yeah. So, and I don't know the exact date, early 90s, 90 time frame. That's when they started transitioning to requiring proof of beneficial use on these, and the ones that predate that we treat as like a no proof required application, and we're not going to require you to submit it. So submit proof in order to perfect that application. So yeah, it's kind of a strange gray area, I guess. So which I guess means you need to be cautious about making sure we know, because that hasn't been verified. So make sure the well location, the place of use might be off a little bit. It wasn't surveyed and verified by us. So, any other questions before we transition to title real quick? No? All right. Okay, so let's talk about title. So water rights transfer by deed in substantially the same manner as in real estate. This is something that a lot of people typically don't understand, and I just want to let you know I'm kind of just gonna scratch the surface of this. So if you have further questions or anything like that, we do have some title trainings on our YouTube website or on YouTube. They're much more in depth and very educational, and I hope you'll feel free to go on there and look at that in further detail, or feel free to ask me questions or talk to me after, or call us. We're always willing to talk about it. So this may be done by land or water deed, and here at the Division of Water Rights, it doesn't matter to us what kind of deed you're using. It could be a quitclaim deed, warranty deed. It doesn't really matter as far as we're concerned. So, something that if there's anything that you should take away from this is probably the one to hit home, that a pertinent water rights transfer silently with that land, with one caveat. And a lot of people don't understand. They think, I didn't mention the water in there, and that's the problem. That people think that they retain that water right and that they can now use it even though they sold that land off. It transferred silently with the land unless you specifically reserve that in the deed. So if there's no reservation language in that deed, it went with that land. And there's been many times that people have not understood that, and it's been costly to them. So if there's anything to take away from this, that should be it. So those deeds need to be recorded in the county where the water is used, so the place of use, and where it's diverted, if the two are different. So if you're straddling the county line, or you divert from the river, 10 miles up, and it's used down here, and it's in a different county, we need you to record that in both counties. So to give you an idea of how kind of title works and how our records work, the county recorder is the official record keeper. They're the ones that that have all the deeds there and recorded. We do not monitor what's coming into the counties. We are relying on the water users and professionals to let us know when water rights are transferred. That's how we operate here. So the county recorders, they maintain the deeds. They maintain records of certificates that are recorded with them. Assignments, which are the transfers of unapproved and unperfected water rights. And they maintain an index of deeds that mention water right numbers. Okay? Here at the division, we maintain the applications, the certificates of beneficial use, all the use records, and any other water rights related documents. And we maintain the owner of record. And let me tell you what I mean by that. We know who the original, let's say it's an application to appropriate, we know who originally appropriated that water, and if any other transfers have happened and people have let us know that that's happened via a report of conveyance, report of water rights conveyance, that will be on our records. However, if it has been sold off but down the road and nobody has reported that to us by submitting a report of conveyance, we won't know that. So the owner of record will still show as, let's say, no reports of conveyance have been submitted. The original appropriator will be the owner of record on our database and in our records. So we're relying heavily on, not just heavily, solely on the water users and the professionals to let us know when those transfers have happened. We've got a question over here, if we can.
So you brought up the word conveyance. Is that the same as divergence?
Sorry, can you?
Originally we were talking about water rights, and when you divert it, you're the one that have those water rights. What do you mean by conveyance then?
So that would be the actual conveyance of the water right, not the water, but the right to divert the water. So that would be a deed conveying that to somebody. Sorry, yeah, that's that can be confusing. It's two separate things. So does that make sense? Okay. So what I'd like to show here is that in a lot of cases there are many discrepancies between the records that are maintained by the county recorder and the records maintained by the state engineer, and that's because people have not notified us when those transfers have occurred, and so we just don't know. Like I said, we don't monitor what's being recorded at the county recorder, so we're waiting for you guys to submit those to us so we can update and get our records accurate. So when we're talking about who can update, most oftentimes, again, this is going to require a professional. If in some instances the owner may be able to update or the applicant may be able to update, and that's when all the deeds in the chain show the water right number explicitly on the deed conveying it to them. So we would call that like a simple transfer, a simple update, and when that water right is explicitly written out on the deed, and not just saying all water rights or any water that I may own, or standard language in it. It has to explicitly recite the water right number, 51-XYZ. We do require, in any other instance, we require a professional to submit that on your behalf, and this could include a professional engineer, licensed land surveyor, title insurance producer, or an attorney. And again, kind of a similar reason why we ask for a professional to submit it for proofs. In this case, what we're looking for is that they do a thorough title search at the county recorders and and making sure that the land and the water always went together, and that if we're going to update ownership, that's the case, that water always went with that land, and this owner can feel comfortable now knowing that they are the true owner of that water right. The mechanism we use to do this is what I've mentioned is a report of water right conveyance, or as we like to call it here, a ROC, and you may hear that term used. This is a document that is attached to the deeds, and basically it's showing the chain of title from the owner of record on the Division of Water Rights records to the current owner, whoever is trying to update title to. So this next part is very important because I believe there may be a certain question asked about it, but if you're trying to update water rights into your name, multiple water rights into your name, you need to submit one report of conveyance, or ROC, per water right you're submitting. So if you take ownership of a farm or a ranch, and there's 5 water rights on there, and you're trying to update to all 5 of those water rights, we would need 5 reports of conveyance. And as I need to stress this again, the owner that you start with in your chain of title needs to be the owner of record on our as shown on the Division of Water Rights records. So a lot of people will see water rights coming in, or conveyances coming in, from just the person they bought it from, and they may not be the original owner of record if the prior owners have not submitted reports of conveyance to us. So just be aware of that. This is our form on our website, and there's 2 forms. There's a 100% and portion form, and they're nearly the same. You'll see one difference, and I'll show the portion form here in just a second. There is a $40 filing fee per water right that you submit, so per report of conveyance. Again, both those forms are in the applications and forms section on our website, and I'll just reiterate. Jim will show you where that is. So I think a lot of us will make reference to that particular link. So this is the portion form. It's pretty self-explanatory. If you're trying to update to an entire water right or the entire interest in a person's water right, then you may submit a 100% form. If you're updating on a water right and somebody owns 1 acre and you're trying to get a 1/4 acre of that, then you would use a portion form. So, and it just kind of delineates what uses or what portion you're trying to update on. That's the main difference on that form. It's pretty self-explanatory. If you have any questions about it, let us know. But when you're updating by appurtenance, we require maps, and they are very helpful to us. As you can imagine, sometimes situations get very complicated, and these maps we rely on heavily. And Sue and Dana, who process these, will thank you very much when you submit good maps that help us update, and it really is incredibly helpful to have that visual aid. Just some general requirements that we ask of you: show us the section, township, and range on the map. Give us a section corner on the map. Put the water right number on there. It's easy when these you have, sometimes we'll see reports of conveyance that have 100 pages. So it really helps when we have all these loose documents to have the water right number on there. Give us a north arrow to orient ourselves. A scale. Identify the parcel as well as the acreage associated, the amount that you're trying to update on, because as you can imagine, a lot of times the acreage is different than the actual parcel. You're not updating on all of the acreage associated with that parcel. And give us a legend. What are you trying to tell us here? So we have an understanding of what you're trying to give us. And I always just say, and whenever I give a training, I always just say, for the most part, if it's a professional map, you've told us what it needs to look like. If it looks professional, it should have all these elements, and we'll hope for that. I'm going to switch from reports of conveyance and talk about addendums for a second. And you may be sitting there wondering, what is an addendum? And I will let you know. An addendum, and this is the only thing that I will read. I'll promise you that. The state engineer shall consider a water rights addendum that is recorded and forwarded to the state engineer by a county recorder as a submitted report of water right conveyance. So what does that mean? What this is a mechanism for a buyer and seller to create a dialogue about what water rights are conveyed. And so this should be happening at the time of a purchase, and we created this mechanism for the buyer and seller to have this. And there's actually, again, a form for water rights, water deed and land deed addendums on our website, same location. And again, we encourage people to have this discussion, whether water is or is not being conveyed. That's what that's there for. It's something that needs to be submitted to the county, recorded with the county recorder, and the county recorder will actually forward it on to us. We will not accept an addendum straight from a professional or the applicant or whoever it is. We require that to come from the county recorder, and we have a pretty good system in place in which they forward it to us, and we update those regularly. We receive a lot of these, and it's very helpful. It's very helpful, and I'll talk about that in just a second. But we've just last year we processed over 2,000 of these suckers, and we're anticipating that to just continue to grow. So this water rights addendum, the addendum is an attachment to a deed. So it's not a standalone document. There will always be a deed attached to it, whether it's a water deed or a land deed. There's two different forms for each scenario. So if you have a land deed, you'll use the addendum to land deed. If you have a water deed, you use the addendum to water deed. Just some basics that we see and encourage people to double check and make sure the grantor and the grantee signs this. We need verification that it's somewhat of an agreement, so we need both parties to sign and verify that. As I was kind of alluding to, we like to look at this as a win-win situation. It's a mechanism for you guys to submit as you're transferring this water water and land to identify what water rights have gone with that. So it's a win for us because we're now aware of who the current owner is, and it helps us maintain our records and kind of keep up with who's now the owner. And it's a win for you guys because not only has it created that dialogue up front, and there's an understanding, people aren't going to convey water they didn't mean to, or there's just a good understanding, and it's documented what went. But it also has no filing fee. So if you do it up front and get this taken care of at the time and record it with the county, they'll send it to us. We won't charge you the $40 filing fee. So it's a win for you. Now we know who that owner is, and so it's a win for us. So we've strongly encouraged people to look at this and consider using this anytime they're buying or selling water or land. And it may be as simple as identifying that they're selling this land and that no water went with it. I mean, we see people's they submit that all the time, saying no water is going with this. So it's straightforward up front, and
Thank you. I've had a little bit of confusion. I understand as you've explained, the water and land deed addenda to be substitutes for a report of conveyance. The instructions, at least for the water deed addenda, say you still file a report of conveyance.
so that actually we went through the legislative process to get that changed.
Okay.
So that should now be eliminated. So kudos to you for actually reading instructions and realizing that was wrong. We recognized it too, and we went through the proper channels to get that taken care of actually this past legislative session. So hopefully you'll be seeing the document updated on there if it's not already. I'll double check that though. It should be updated at this point. So yeah. So kudos to you on actually reading.
When is that effective then with the document change? So you no longer have to file an RLC if you do an addendum?
And you never the language just didn't get. I think it was 2011 that went into effect, and we never required a report of conveyance. As I understand it, we just had some incorrect language in there, and it was never properly taken care of because we had to go through the legislation to actually get it changed. So the report of conveyance, the addendum actually acts as a report of conveyance. So to file a separate report of conveyance to go with it is redundant. And so the changes need to be made in that language. And it was confusing, and we had to talk to many applicants and professionals who were very confused by that, and we said, yes, it is very confusing. Let us get that changed. All right.
Question.
Yeah.
All right, on here it also says the grantee must keep current mailing address with DWRI. How long is that? What's that process?
So, yes. So on the addendum, we require a current mailing address to be included on there. So that's where that comes in. But if you're the owner on a water right and you move or your mailing address changes, we have a form on our website that allows you to go in and update your mailing address, because we don't know if you've moved, so we need you to tell us, and we will continue to send all our notices, and your proof due notice, your notice of lapse, everything will go to the address we have of record. So that form online is really simple, really straightforward, quick and easy, and we'll get that updated for you. So if if your address changes, let us know. But on that, if you submit an addendum, just make sure you put the mailing address, current mailing address on there for the grantee, because that's what we will use on our records. All right. So that covers that bullet point there. And so again, if you know it's going to change, just jump on our website, put in your new one, and we'll get that updated for you. So I just want to kind of reiterate a few things. If ownership changes, it's in order to get it changed on our records, it's done via a report of water right conveyance, and that may be in the form of an addendum acting as a report of conveyance. Typically, a report of conveyance will require the assistance of a professional, except when all deeds show the water right number specifically. Pertinent water right transfers do require a map. And we get asked about this periodically, but competing ROCs are a title controversy, and we don't resolve those. That's done outside of the state engineer's office, typically through the court. So when we receive competing ROCs, we'll flag them, and we no longer, it's between you guys and the courts. So, and just as a kind of a precautionary note, we see a lot of people that purchase water rights and think that they've purchased something, and we really just caution people to do their due diligence and make sure they verify what exactly they are purchasing, and we're hoping that we've put some processes in place to help allow that to happen. But it is a kind of a buyer's beware market, just like with anything out there. Just make sure you're being cautious and careful and do your due diligence. So I guess with that, go ahead and answer any questions, and if you're wondering where this picture is taken, it's the High Uintas, and we won't be seeing that kind of picture till this was early June, and we won't be seeing that this year. It's gonna be quite snowed in for quite a while. Yeah.
I'm wondering what happens to what I call orphaned rights. So an example of that would be the Smith family homesteaded in 1870, and they had quite a bit of land and some rights that were not appurtenant to the property for various reasons. Then through the generations and years, the land was, divided off. It's typical. And current generations didn't even know that there were rights around, and they weren't appurtenant. So how does anybody lay claim to a right that may have, the last name on it may have been put on it in 1903 or so long ago? How are they just orphaned at this point?
So they were not. You're trying to say they were not appurtenant to
They
that
were not
land?
appurtenant. Yeah, they were not appurtenant.
So
It was a big piece of land and not appurtenant. So basically the question is, what about these just free-floating rights that nobody appears to be able to claim anymore, because unless there is a way? That's what I'm asking.
yeah. So I guess from our perspective, you're looking at it's if it's a perfected water right, it should be appurtenant to somewhere, right? And
Right.
so we would look at where it is appurtenant to, and those people should have some kind of chain of title back to, we would look for a chain of title back to that person from that 1903 in your case.
Okay,
And
so
that's-
if they're not perfected, then they're just not perfected.
If they're not perfected, it would be a different avenue, and
Yeah.
for a water right dating back to 1903 or before, you'd be looking at probably a diligence claim being submitted.
Well, the point I'm making is just the name on it is so long ago, and subsequent heirs who would have received this maybe in their wills and such didn't, and nobody knows, and all of a sudden they're made aware
Yeah,
of
and
land that they,
and that can be a real challenge.
Yeah.
We've seen people do extensive
Yeah.
research at the county recorders trying to show a chain of title back.
Okay.
And I would be talking when it
Okay.
is appurtenant there. But yeah, it can be a real challenge when you're
It's
dealing
just-
with multiple
takes-
generations back. And,
Okay, creativity and put on your boxing gloves and get ready to figure it out. Okay.
yeah,
Thank you.
yes. I wish I could give you a.
Chris, in those situations too that we've come across, when we just cannot find a chain of title to be completed and pull up through, there is a process through the court system of quiet title
Sure.
that you can actually pursue, and that may be where you have to go. If you just can't figure it out, there's no chain to follow through, then you actually have to petition the court in a quiet title action to get clear title to those water rights.
And I appreciate that input, and that's that is an avenue, and actually, it can be expensive. I know that, but sometimes we see people expending a lot of time, energy, and money, and don't come to a conclusion. So that is sometimes that actually might be the quicker and cheaper route even up front. But all right.